My Lord, I will reply first on issue 1. One point that Littlewoods have not been able to meet is the significance of the prohibition at section 80 subsection 7. Littlewoods have contended that any restitution claim for interest is freestanding, but that cannot be correct if what Littlewoods mean is that the restitution claim for interest is freestanding of the overpayment of VAT. My Lord, there are 2 points in support of that. First, a point I've already made, so I'll take it very quickly, and that's paragraph 102 of Lord Nicholls' speech in Sempra. I don't ask you to go back to that because you've been to it twice already, but for your note, it's volume 11, tab 88, yep. And paragraph 102 is at page 3622.
Yep.
The point that is clear from paragraph 102 is that the legal basis for the restitution claim for interest in that case was the initial payment of ACT. Lord Nicholls described the recovery of the interest as part of the restitution in respect of the payment of ACT. And so the initial payment was the foundation for the restitution claim to recover the use value of the money. Now, my Lord, precisely the same point emerged yesterday afternoon in response to a question put by my Lord, Lord Reid. Lord Reid suggested that in Sempra, the unjust element, the thing that grounded the restitution claim, was the premature payment of ACT, and Littlewoods agreed with that analysis. The significance of that analysis is that if the unjust element in Sempra was premature payment, that explains why the unjust element was not removed, was not overtaken, when the unlawful requirement to pay ACT was itself overtaken by the lawful requirement to pay MCT. The premature payment had still occurred, and the consequences of that payment had not yet fully been reversed. Now, that was the position in Sempra. Compare the present case. In the present case, the unjust element, the thing that grounds the restitution claim, can only be the overpayment of the VAT. Without that element, there is no common law claim for the use value of the money. And this, I say, underlines the significance of Section 80, subsection 7. Section 80 provides a statutory right to the repayment of the overpaid VAT, but then Section 80, subsection 7 states in terms that other than under the VAT Act, the commissioners are not liable to repay the overpaid VAT. And so the significance of Section 80, subsection 7 is that it specifically removes the unjust element, or overrules that what might otherwise be the unjust element, and thereby rules out any common law claim that relies on the overpayment of VAT. And in my submission, that is fatal to Littlewoods' restitution claim in this case. And, my Lord, the Court will recall that that reasoning formed part of the reasoning of Mr. Justice Henderson in Chalk. I took you to that in opening. Again, for your note, it's volume 6, tab 59, between paragraphs 69 and 74, which is MS 2339 to 2341. Again, just to note the point, Chalk itself was the, as it were, the forerunner, was version 1.0 of this litigation. Chalk was similarly a claim, a situation where a restitution claim was made and was confronted with Section 78, Section 80. And so the same Section 78, Section 80 issue arose in Chalk as arose in these proceedings. Ultimately, the Chalk litigation founded on the basis that in any event, regardless of what any EU law right might say in relation to recovery of interest, the claim was time barred on the basis of Section 32, the Limitation Act. So that claim stopped after the Court of Appeal, and then Littlewoods, this claim, obviously not having the Section 32 Limitation Act issue, was able to be the vehicle to address all the issues surrounding Section 78, Section 80, as well as EU law. So, my Lord, that's the first point I make on issue 1. The second point is that Section 80, subsection 7, is also one of 2 reasons why, on the basis of the Monroe Principle, Littlewoods' common law claim is inconsistent with the legislative scheme. This is because Section 80 of the VAT Act provides a claim for recovery of overpaid VAT, but then prevents any other route of recovery of those amounts. Section 80 sets out various conditions and limitations applicable to the statutory claim, and Littlewood's approach to Section 78 would mean that notwithstanding the dedicated scheme in Section 80 that excluded common law restitution law claims for overpaid VAT, restitution claims for the loss of use of overpaid VAT could be pursued free from any of the restrictions or defences set out in Section 80. And presumably, such claims for loss of use could also be pursued even when there was no possible claim for recovery of the overpaid VAT under Section 80. Now, this point is certainly a good point in my submission if you accept my first point in relation to the significance of Section 80, subsection 7, to the existence of a restitution cause of action. But even if you do not accept that point, it is still the case that a common law claim for interest would be anomalous given the effect of Section 80 in relation to statutory claims for recovery of VAT. And for that reason, a common law claim for interest would still, in the Monroe sense, be inconsistent with a key feature of the statutory scheme. The other reason for Monroe inconsistency depends on looking only at Section 78. Looked at without reference to the Section 78 reservation, those words at the end of subsection 1, Section 78 1A operates as an adjunct to Section 80 repayment claims in respect of claims for interest. Now, it is correct that other parts of Section 78 may operate in situations other than those covered by Section 80, but Section 78 1A will operate in all cases of repayment under Section 80. And so to that extent, the two are legitimately and relevantly tied together. Under Section 78, and the regulations referred to under Section 78.3, there is...
Sorry, is that right? You say it will operate in all cases of Section 80?
Section 78 1A will operate in all cases.
Because in all cases there will have been an error. Is that
yes, so I take the point.
There's a cross-reference, isn't there, to... It applies where there's liability under Section 80.
That's right.
Subsection 2A.
Yes, it's tab 17 in Volume 1 at page 927. Yes, 78.1. I think my Lord Culmouth's point is, what about situations where there was no official error, that being itself a condition for Section 78 interest? But I take the point that in relation to Section 78 there is this additional condition.
I mean, it may not matter here because
it certainly doesn't matter here, as there's never been any question but that the levy of VAT was the result of error in the sense of misunderstanding the effect of EU law.
Maybe it would have to be disapplied on a St. Giorgio basis if it was inconsistent with an EU right of recovery.
Well, yes, but if that were so, I think all I say in relation to the official error requirement is that it's simply one other specific feature of the statutory scheme.
Yeah.
That
I mean, don't take time on it if it's not an issue here.
Only to say it's another matter that would demonstrate a Monroe-type inconsistency if there was a common law claim for restitutionary interest. But reading the Section 78 reservation, a point I made in opening, so as to allow a common law claim for restitution, would render Section 78 1A at least redundant. And for that reason, there is a Monroe inconsistency. Now, Littlewoods say, now that doesn't matter, because Section 78 was only intended to be a residual provision, therefore there is no inconsistency. But in my submission, that is the wrong way of looking at Section 78 and the Section 78 reservation. At the time it was enacted, the Section 78 reservation would have been and could only have been understood as referring to other statutory claims for interest. Although the reservation makes it clear that Section 78 would give way to other statutory claims on this reading, the description of Section 78 as residual is, in my submission, a little misleading, because the practical effect of Section 78 was, in fact, to ensure that in all cases where there had been an overpayment, there would be a statutory right to interest. And so for this reason, the obvious way of approaching the purpose of Section 78 at the time it was enacted is that the purpose was to ensure a statute-based claim for interest in all overpayment cases. It was a provision about universal coverage rather than a residual provision. Now, you were referred in passing yesterday to Hansard. I'm not sure that this is a situation where the conditions for reference to Hansard are met, but I won't take that point. For your note, the reference is volume 2 at tab 24. I don't ask you to go to that, but can I just make this observation about that? The only point that one can discern from that extract is the existence of a desire for the previous ex gratia payments that had been made by the commissioners to be replaced by payments under a statutory scheme. Apart from that, all you can get from that extract is that when the provision was proposed in committee, a number of MPs suggested amendments, but none of those amendments was actually pursued. You don't get anything more than that from it. So if you can look at that extract in Hansard for the purpose of identifying the purpose of the scheme, purpose of the provision, you can go no further than a desire that interest should be paid pursuant to statutory provisions. Then the next point, of course, is as a matter of statutory construction, the question is whether the Section 78 reservation is now to be understood to mean that Section 78 interest should give way in the face of common law claims. In terms of the applicable principles, there are two cases I'd like to take you to. The first is Quintervale, which you were taken to this morning, so I can be brief in relation to this. My Lord, it's one of the two cases in the additional file that was handed up. I think it's behind the first tab.
Yes, it is.
And can I take you back to the passage in Lord Bingham's speech that you looked at this morning? And for my purposes, the important paragraphs are paragraph 8 and then paragraph 10. Paragraph 8 starts on page 695. There are... So far as paragraph 8 is concerned, there are 3 points that emerge from that. The first, right at the beginning of the paragraph, the basic task of the court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment. The second point, which is between letters C and D, put generally, is making the point that construction is not a mechanistic exercise. And then the final point in the paragraph, just against the letter E, the court's task, within the permissible bounds of interpretation, is to give effect to Parliament's purpose. So the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. Now, you were taken to paragraph 9 this morning. I don't ask you to look at that again. Paragraph 10, and the quotation from the speech of Lord Wilberforce, in Royal College of Nursing, the quotation being on page 696. If you'd be so kind as to look at that.
Yes.
I say there are 5 points emerging from that quotation. Firstly, this is the beginning of the passage quoted, that you should have regard to the state of affairs existing and known to Parliament to be existing at the time of the enactment. It is a fair presumption, said Lord Wilberforce, that Parliament's policy or intention is directed to that state of affairs. The second point, and this is just against the letter C, was what to do when considering a fresh set of facts which come into existence and which bear on the policy. The first point is whether they can be properly considered to be, the new matter can be considered as a matter of the same genus of facts as those to which the express policy had been formulated. So again, looking to the purpose of the Act and looking to see whether the new circumstance, looking to see in what way were the new circumstances relevant to the purpose of the Act. The next point, against letter C, they may also be held to do so if there can be detected a clear purpose in the legislation, which can only be fulfilled if the extension is made. And then 3 further points, starting against letter D. The court should be less willing to extend express meanings if it is clear that the Act in question was designed to be restrictive or circumscribed in its operation, rather than liberal or permissive. And then next point, they will be much less willing to do so where the subject matter is different in kind or dimension from that which the legislation was passed. And then the final point is that in any event, the court must not ask the question, what would Parliament have done, must not step into the shoes of the legislature. So that's what was stated in that case to be an authoritative approach to the question of interpretation in this sort of scenario. My Lord, by way of example of the application of those principles, could you look next at the judgment of this court in Crown on the application of Child Poverty Action Group and Secretary of State for Work and Pensions? That's the next tab in that file, my Lord. And first at the head note, just to get the context. It's a mercifully short head note. It says, the only right to recover overpaid social security benefits made pursuant to an erroneous award is that conferred by Section 71 of the Social Security Administration Act 1992, which applies only where there has been overpayment through either misrepresentation or non-disclosure. Such overpayments made in accordance with an award cannot therefore be recovered by way of a restitutionary claim at common law as money paid by mistake of fact or law. And the same conclusion is reflected in the holding between E and F. And if you go to the judgment of Lord Dyson, that judgment starts at page 27, but if you could go to page 28, it's the passage between paragraph 21 and up to and including paragraph 24 on the next page. And again, if I may take you through those paragraphs. So the first point in paragraph 21 is recognition of the circumstances at the time of the enactment. So Lord Dyson said, in deciding whether Parliament intended in 1986 and again in 1992 that statutory provisions were to be an exhaustive code for recovery of overpayments by the Secretary of State, it is in my view relevant to recognise that at the time of those enactments there was no realistic possibility that the Secretary of State could recover overpayments of benefit in a common law action. By 1986, the law of unjust enrichment or restitution was by no means in its infancy. It was well understood that a person was in principle entitled to recover at common law money paid under mistake of fact. But under the statutory scheme then in force, there would have been no relevant mistake on which the Secretary of State could have founded such a claim. And then moving down to the end of the paragraph, the last 5 lines against the left-hand margin, the sentence starts, in my view. In my view, the correct premise on which to proceed is that Section 53 of the 1986 Act and Section 71 of the 1992 Act were drafted on the basis that, as the law then stood, the Secretary of State was not entitled at common law to recover overpayments resulting from errors in the calculation of the award. And then at paragraph 22, Lord Dyson continues as follows. At first sight, therefore, one might think that this should lead to the conclusion that the statutory provisions for recovery of overpayments were intended to be exhaustive of the right to recovery. There was no common law right to recovery. A statutory right to recovery was introduced. By definition, therefore, the statutory right to recovery was intended to be exhaustive. That was the view of the Court of Appeal, as expressed in paragraphs 25 and 27 of the judgment of Lord Justice Sedley. And I agree with it. At paragraph 27, he pithily summarised the argument of Mr. Drabble, Queen's Counsel, repeated in this court, which is not that Section 71 has excluded any power of recovery that was previously available, but that it has created a power of recovery where otherwise there is none. But Mr. Eadie has another string to his bow. He submits that even if at the time of the enactment, sections 53 and 71, the Secretary of State had no right to recover at common law, it does not follow that if there were a change in circumstances so that such a right to recover were to arise in the future, it would be precluded by the statutory provisions. As I understand it, Mr. Eadie does not contend the meaning of sections 53 and 71 could change over time. In this context, that would obviously be an untenable proposition. The position would, of course, be otherwise if Section 71 were later amended expressly or by necessary implication, but that is not suggested here. Mr. Eadie's argument is directed to the true meaning of Section 71 in its unamended form, but he submits that it cannot be construed as having prospectively excluded by necessary implication a right which was not in contemplation at the time when it was enacted. In other words, Parliament cannot be taken to have excluded the possibility of a common law right to recovery arising in the future under a differently framed decision-making scheme. I cannot accept this argument. I proceed on the hypothesis that, as I have already stated, at the time when the statutory scheme for recovery of overpayments was enacted, there was no non-statutory route for recovery. The statutory scheme was exhaustive at that time. It carefully delineated the boundaries. They were limited to recovery of payments made pursuant to an award by the adjudicating authorities, which was in error by reason of a misrepresentation or failure to disclose any material fact. Simple error on the part of the adjudicating authorities was excluded. I would not go so far as to say that Parliament can be taken to have excluded the possibility of a common law right to recovery under a differently framed decision-making scheme. That would be to go too far, since it would depend on the terms of the differently framed scheme. So, pausing there, Lord Dyson's clear conclusion was that the correct analysis was look at the starting point, look at the point of enactment. At that point, the remedy created was clearly intended to be an exhaustive remedy because there would have been no knowledge of any common law right. And that position does not change simply because there have been subsequent developments in the common law.
Perhaps the approach to this case that we adopted in ITC.
Well, no, precisely so. And one other reference I would give to you, and I don't ask you to look at this, my lord, is a reference to your own judgment in ITC, which is volume 8, tab 72, paragraphs 85 to 86, and that's the point at which you make reference precisely to this judgment of Lord Dyson in the CPAG case. Now, in the present case, there is no reason at all to read the Section 78 reservation as now including reference to common law claims. At the time of enactment, Parliament's intention can be taken to have been to put interest claims on a statutory footing, so that a statutory provision applied in all cases where there had been an overpayment. Now, that purpose is not fulfilled at all by construing the reservation so as to include common law claims, and rather, such a construction would be to entirely undermine the statutory purpose. It would be against the nature of the statutory purpose insofar as it can be discerned. So where this leads you, in my submission, is the conclusion that on a proper construction of Section 78, that provision on its own terms is inconsistent with the availability of a common law claim for interest by reference to the Monroe Principle. My Lord, that is all I wanted to say on issue 1. May I turn now to issue 2? First point, or first couple of points I wish to make were in relation to the judgment of the Court of Justice and the reference in this case. In my submission, one has to return to the importance of reading that string of paragraphs, paragraphs 25 to 30, to reading those paragraphs in the round. The problem with Littlewoods' submissions on issue 2 before you is that they cannot make sense of paragraph 30 of the judgment or any part of it, be it the reference to have regard to all circumstances of the case or the particular matters picked out by the Court of Justice. If Littlewoods were right and the Court of Justice only referred the question back in this case for consideration by the court because it had no value or no evidence as to the use value of the money that was an issue in these proceedings, if that were right, why is it that the question of use value is not referred to anywhere within paragraph 30 of the judgment? That said, one can also say that the Court of Justice was clearly aware that Littlewoods' claim in these proceedings was for an amount in the region of £1 billion. The reference for that in the judgment is paragraph 14 of the judgment of the Court of Justice, which is at page MS 1423. And no doubt one can assume quite readily that the Court of Justice was able to take notice of the significant difference between that £1 billion claim and the statutory interest that had been paid. But again, there is no mention of that anywhere within paragraph 30 of the judgment. Mr. Rabinowicz's further point concerned the content of the right, and he invited you to distinguish, so far as concerned the relevance of the principle of effectiveness, between the content of the right and the enforcement of the right. I say that that distinction cannot live with paragraphs 27 and 28 of the judgment. It is clear that in those paragraphs, when the court describes the relevance of of the principle of effectiveness. It talks about the content of the right in terms of the rate of interest and the method of calculation. And so in this situation, the Court of Justice is not saying that effectiveness is only relevant to the question of enforcement. It is referring directly to matters that go to the heart of the content of the right. Overall, so far as the judgment in Littlewoods is concerned, the reference is concerned, Littlewood's reading of the judgment, if that reading is right, there is only one possible answer to the content of the right, that is reimbursement on Mr. Rabinowicz's submissions. And if that was so, the court should, as it did in Irami, simply have stated that there was an in-principle incompatibility. And I come back to the point that what is wrong with Littlewood's approach in its submissions in this case is that is plainly not what the court did. Instead, it took the course that it did at paragraph 30 of the judgment. May I deal now with the three cases that...
I mean, just before we leave it, on page 579 MS in volume 2, do you agree that the principle of effectiveness is treated as including the principle that whatever is paid should not deprive the taxpayer of an adequate indemnity? That's what it seems to be in paragraph 28 and 29.
Yeah, yes, I can see that is the yes. Looking at paragraph 29, the reference to that principle must be a reference to effectiveness.
So they're saying
yes.
When you ask yourself what does effectiveness require, it requires, quotes, an adequate indemnity.
Exactly. And then
you ask, what does that mean?
Exactly. It raises the further question, what does adequate indemnity mean? And then you'll take it to paragraph 30. So I don't dispute that, the premise of my submission is that one must read this run of paragraphs together and make of them a coherent whole. And so I don't dispute that proposition at all. Coming to the three cases, Marshall was the first case.
Yes.
I'll take you to this briefly. It's volume 3, tab 37, which starts at page 1468. And I only intend you to take you to the judgment of the court. As this court is aware, Marshall was the case about sex discrimination remedies, remedies under the Sex Discrimination Act. The problem, so perceived the Industrial Tribunal, was the existence of the statutory cap on compensation, 6,000 odd at the time of the claim, and the further problem was that the Industrial Tribunal had no power to award interest on damages. There was no Section 35A equivalent within the Industrial Tribunal rules. But if you go to the judgment of the court at paragraph 25, that is at page 1506.
Thank you.
Yes. The passage starts at the top of that page under the heading Meaning and Scope of Article 6 of the Directive. Then 25 says this: such requirements, in terms of equal treatment, necessarily entail that the particular circumstances of each breach of the principle of equal treatment should be taken into account. In the event of discriminatory dismissal, contrary to Article 5.1 of the Directive, a situation of equality could not be restored without either reinstating the victim of discrimination or, in the alternative, granting financial compensation for the loss and damage sustained. And 26, where financial compensation is the measure adopted in order to achieve the objective indicated above, it must be adequate, in that it must enable the loss and damage actually sustained as a result of the discriminatory dismissal to be made good in full in accordance with the applicable national rules. Then down further on that page, paragraph 31 deals with the court dealing with interest. With regard to the second part of the second question, relating to the award of interest, suffice it to say that full compensation for the loss and damage sustained as a result of discriminatory dismissal cannot leave out of account factors such as the effluxion of time, which may in fact reduce its value. The award of interest in accordance with the applicable national rules must therefore be regarded as an essential component of compensation for the purposes of restoring real equality of treatment. Important to have in mind, I say, all of that is said within the context of a specific EU law provision, the Equal Treatment Directive. And the observations that the court makes at paragraph 26 and paragraph 31 are each directed towards restoring, or rather remedying, a breach of the equal treatment principle found within that directive. So, in my submission, what the court says, in particular at paragraph 31 of the judgment, is referring no more and no less to the operation of the principle of equal treatment, the principle at the heart of that directive. There's nothing to be derived from this case that reads over to the situation before this court. I accept that in the course of the extensive references that Mr. Rabinowitz took you to this morning, there were two passages where there was reference to the San Giorgio right. Fully accept that. But bear in mind that at that time, the San Giorgio right was only understood in terms of a right to repayment of charges that had been unlawfully levied. There's nothing that one can see in Marshall that says anything, or realistically can be thought to say anything about the element of the San Giorgio right that is now an issue concerning the obligation to pay interest. Also, coming back to the Littlewoods reference, if Marshall is so important, it is striking that the Court of Justice makes no reference to it at all in its judgment. The Court of Justice is, when it writes judgments, habitually footnotes, cites authorities, previous judgments that it believes to be relevant to the statements of principle it makes. No reference to Marshall at all. The fact that Mr. Rabinowitz can give you a legion of references to Marshall in his own client's observations to the court, and can then say, well, look, the commissioners referred to it as well, because they did, responding to the observations that Littlewoods had made, so saying it was not relevant, only underlines the fact that the court itself made no reference at all to Marshall. Putting it briefly, Occam's razor applies here. There's no need to go about looking for elaborate explanations of the derivation of the words adequate indemnity when a straightforward one is staring you in the face. The straightforward explanation is the observation of the commissioners that you saw recorded at paragraph 11 of the Advocate General's opinion. The explanation of the phrase is not to be found in the judgment some 15, 20 years before of a Court of Justice on an entirely unrelated subject matter. Well, that's Marshall. The next point is Irami. And this is at volume 3, this time tab 32, my lord. Again, I'll only ask you to look at passages in the judgment. In the course of his submissions, Mr. Rabinowitz referred you to the observations made by the governments of Spain and Portugal, as recorded in the Advocate General's opinion. However, what is important is that those observations were not actually directed to the point on which the court decided the case. That point is the one at paragraph 27 of the judgment. And paragraph 27 is on page 1371, the last page behind tab 32. And as the court has seen, the point on which the case was decided was the mismatch between the period for which interest was available under Romanian law and the period for which interest had to be available as a matter of EU law. May I ask you also to note paragraph 23 of the judgment, Irami?
Sorry, which is the paragraph you refer to?
27, my
27.
lord. Yeah. And then 23, on the bottom of the facing page 1370, note there that to the extent one has a cross-reference there in terms of the content of the right, the rate of interest and method of calculation, which is the last line on page 1370, the court then cross-refers back to those paragraphs 27 and 28 in Littlewoods. Another point made by Mr. Rabinowitz by reference to the Advocate General's opinion in Irami is that the Advocate General in that case refers to the San Giorgio right to recovery of the overpaid tax as ranking equivalent to the EU law obligation to pay interest. Again, important to have well in mind that that matter, this notion of ranking equally, which was at the heart of Mr. Justice Henderson's reasoning in this case, does not come through to the judgment of the court at all. On no occasion has the Court of Justice made this point about the equal ranking of the rights. And for the reasons I gave in opening, it's not a point that actually takes you anywhere when you come to consider the respective content of each of those elements of the San Giorgio right. My Lord, finally on Wortmann, that was in volume 5, I believe, at tab 50. Again, I invite you to focus on the reasoning of the court. The court's judgment starts at page 1996. The reasoning in that case was all directed towards construing the effect of various provisions within the Customs Code, I believe, or the German Tax Code. The Customs Code, for example, is referred to paragraph 23, page 2000, under the heading "The question referred for a preliminary ruling." Ultimately, the court's conclusion at paragraph 36 was that there was no provision in the Customs Code that covered whether or not a right to reimbursement gave rise to an obligation to pay interest. That's at page 2001, paragraph 36. The court then followed on from that, at paragraphs 37 to 38, referring to the Zuckerfabrik judgment, to say that in those circumstances, this is the conclusion at the end of paragraph 38, then the repayment, the reimbursement that was made, had to be increased by the corresponding interest. That was the language used by the court. That's all the court says about an obligation to pay interest, and in my submission, that tells you nothing at all that will be of any use when it comes to determining issue 2 in this appeal. My Lord, unless I can assist you further, those are the points in reply.
Can I just, I think I have to put to this, and we've got to a stage where you're offering us quite different interpretations of the judgment in this case of the European Court. If we end up in the unhappy position of thinking that it's not clear what the court was saying, I suppose we can't avoid a reference, can we? I mean, I'm not saying we want to go there, but...
You would have noted it is conspicuous that neither Mr. Rabinovitz nor I have been pressing a reference upon you. As my Lord Reid observed in argument this morning, it was a judgment of the Grand Chamber of the Court.
And we have to approach it on the basis that they were attempting to provide a clear answer to the questions put to them in this particular case.
Indeed.
One which would enable us to decide the matter.
Precisely. Well, the assumption must be, understandably, that everyone's approaching the matter in good faith, directing themselves towards getting the answer. So,
You'd think that.
I think
Reasoning in cases where there are many judges make that quite difficult, quite often.
Well, yes, in particular...
Hence the fact you tend to get a bit of one and a bit of the other, and a bit of Uncle Tom Cobley and a bit of all.
Yes, particularly so when it's all boiled down into a single judgment. Yes. No, but again, a matter of reality, that must be so. I think the straight answer to my Lord's question is that in the last resort, one couldn't rule out a further reference, but I really
it's
don't
difficult
invite
to say,
you to go there.
That either argument is act clear. Especially since the English courts have taken a entirely different view from one side.
Yes.
On the construction of these very questions.
Yes.
Could I ask you do you want to say something to that? Or?
I didn't. No. I can. Yes.
The other point is you said that Marshall really is sort of, in a sense, you put that in a sort of historical category of a special case, but the cases that are referred to with some weight in this case are Metallgesellschaft.
Yes.
And the other case, the test
claims.
I mean, we haven't been referred to that. I'm not saying we should do, but are you saying that they don't really take the arguments any further?
I don't say that they do. Metallgesellschaft is Semper, isn't it, I think?
Where it started.
Yes. And so to that extent, the situation before the court in that case was to decide the existence or not of an EU law remedy in a situation where there had been a premature unlawful payment of tax. And To the extent that one can get anything from the judgment in Methel-Gesellschaft, with respect, I think one sees all that one can get from that.
On the the issue of what is meant by adequate compensation,
That's not something the court touches on in
and
Methel-Gesellschaft.
ditto the test claimants case.
Quite so, but again, there's no that language is certainly not derived from either of those cases.
Well, I presume both you and Mr. Rabinovitz maintain that the meaning of the judgment is indeed act clair. You simply disagree as to what that meaning is.
Yes, the fact that the meaning is difficult doesn't mean that the judgment is ambiguous.
And can't be said that it's common ground, that it's act clair, therefore we can't refer, because that's the decision
Well,
for us.
that is also true.
To understand your point about reading all these paragraphs 25 to 30 in context, would I be right to say that in your view, in your submission, it comes to this, that 26 creates a right to interest, which is then subject, as far as is relevant, to principle of effectiveness. The principle of effectiveness, and we see what it is in 28, gives rise to a test of adequate indemnity, which you might be construing as something like reasonable redress.
Yes.
Standing what is said in paragraph 30,
Yes, my lord.
where they seem to look to the differential between the principal and the interest payment, which would, as I understand your case, be irrelevant if Littlewoods is correct.
Quite so, my lord, yes.
That's a fair summary of what you're
yes,
saying.
it is.
Yes, thank you.
Mr. Rabinovitz, on issue 1.
My lord, issue 1. I'm going to deal with this shortly because I think we've probably taken enough time on issue 1 anyway. My learned friend said in the course of his submissions that the effect of section 80 subsection 7 was to remove the unjust element for a claim for the interest. With respect to my learned friend, that is incoherent. The unjust element for the claim in unjust enrichment with respect to the interest is the fact that a mistake was made. That is what constitutes the unjust element for that purpose. My learned friend also said that one of the problems with our submission, I think this reflected a point that my Lord Reid had put to me this morning, one of the problems with our interpretation of allowing a common law claim as part of the words which make clear that this is residual, not sure else to refer to those words, is that in relation to that claim, one isn't subject to some of the defences, or to the defences, that would affect the claim for principle in relation to section 80 subsection 7. The difficulty about my learned friend's submission is that it proves too much. The difficulty, as I say, is that there is no, for example, passing on defence in any of section 85A of the VAT Act, nor is there a passing on defence in section 84(8) of the VAT Act. And if that is so, there is no reason why the fact that there is no passing on defence in relation to the common law claim is either here or there. My learned friend also said, in relation to the relationship between section 78 and section 81, that something can be drawn from the fact that section 78(1)A will always operate in tandem with section 80. What my learned friend didn't say, because he cannot say that, is that any of the other provisions in section 78(1) will always operate in tandem with section 80. And I've already given your lordship the example of section 78(1)B, which won't operate in tandem with section 80. So with respect, the notion that these provisions always march together is not correct. Finally, in relation to Child Poverty Action Group, Melinda Friend seeks to draw something from that, from the speech of Lord Dyson between paragraphs 21 and 25. The critical difference between that case and this case is that there the court was dealing with a provision in a statutory scheme which everyone accepted was exhaustive.
And you say this one is permissive?
This one is expressly permissive. Now, if you start with a scheme which everyone agrees is exhaustive, and someone says, but they didn't know there was a common law claim, the argument that because they didn't know there was a common law claim, that is not caught by the exhaustion effect of the exhaustive scheme, one can see why Lord Dyson had no difficulty rejecting that. But that is not this case. We are dealing with a scheme which is expressly non-exhaustive. And the only issue for your lordships, again, is where you come to those words of reservation, if you like, is there any basis in those words for distinguishing between claims by reference to the source? Is the source common law or is the source statutory? And in our submission, as your lordship knows, there is nothing. Lords, those were my points of view. I don't know whether your lordships want me to say anything about a reference.
Well, I think as it's been raised, it's only right you should, yes.
Your lordships will understand, thus far we have had 4 judges of the lower courts agreeing with us. So we, with respect, would submit that it is that clear. Now, I know your lordships
But you pray that in aid to say, A, it's that clear in your favour, and B, if it isn't.
It's certainly not exactly that, my lord. But it really cannot be, particularly, my learned friend ignores this in his reply. Your lordship saw Wortman, the Advocate General. The Advocate General in Wortman certainly gives the interpretation of Littlewoods, which is what we give, which is that what is required is a commensurate payment. Now, if it's not that clear to him, sorry, let me put that differently. If it's not that clear in a way that we're right, then it really is not that clear. The only problem with a reference, my lord, is that it will be 2 years. Heaven alone knows where we will be in relation to the European Court. And one doesn't know whether anything that comes back will be beyond them saying, we thought it was clear. Read paragraphs, whatever it is they say. So, again, if your lordships can, and particularly if you were able to decide it in our favour, we would say don't refer. But if you can't, then obviously it isn't that clear, my lords.
Thank you very much. We'll take 20 minutes to consider where we've got to, and we'll come back and certainly try and come back at quarter past 3. Thank you very much. Court's now adjourned. Mr. Rabinovich, Lord Clerk has a question for you.
Mr. Rabinovich, what is the position if we were to decline to refer the issue back to the European Court, and if that would have and if we were to decide issue 1 against you, issue 2, sorry, against you, then does it follow? Well, what follows from that?
I think that would be the end of the road, my lord.
It will be the end of the.
If you decide issue 1 and issue 2
Yeah,
against us.
Yeah. So there's no middle way between a summary, an award of interest on a summary basis and awarding interest in some kind of compound basis.
I think the issue in the case is whether the simple interest, the issue is whether less than 24% is adequate. If your lordship is saying to me, is it open to this court to say 24% is inadequate, but if you got to 50%, that would start becoming adequate? I don't see why that wouldn't be something which was available to your lordships. Our position is that there has been a finding made as to the gap, and it shows that only 24% has been paid, in other words, 75% unpaid. If the conclusion your lordships arrived at is that adequate doesn't mean full or even commensurate, but it certainly means more than 24%, and you were of the view that it has to be at least half, there is nothing that has happened, given that what one is doing is trying to apply the decision of the Court of Justice, which would stop your lordships applying whatever your lordship considered was an adequate indemnity. Now that is all, again, subject to issue 6, because of course, on my learned friend's case, even if we're right about adequate indemnity and we have a Sempra claim, on his analysis we would only get, I think, 70 million. That is his primary position. In other words, if you follow the approach of the Court of Appeal before it changed its mind and went back to the way Mr. Justice Henderson approached it, the award would be 70 million. There, the focus would be on the actual use to which the money was put by the revenue, rather than treating the claim, that's to say, treating what they received as the use value of money. Now, that gives you a huge differential, obviously the difference between 1.2 and 70 million pounds. But I think the short, I've taken too long to say this is the short
That's
answer, but the short answer is there is nothing that locks you in to any particular view as to what adequate indemnity means, such that you would have to award us the full amount. You perfectly come to the conclusion that adequate indemnity doesn't mean commensurate with the full extent of the loss, but it does mean somewhere between 24% and that position.
I mean, the way issue 2 is framed is whether Section 78, the exclusion, as it were, the provision of Section 78 violates the principle of effectiveness.
Exactly.
It's not, if it does, do you get the whole compound
No,
interest?
indeed. I mean,
It's simply
we
does it
get the whole amount simply because our claim is an unjust enrichment, and the court has to disapply Section 78. And on one approach to what the English law of unjust enrichment regards as the benefit received by the revenue, we're talking about the figure of, is it 1.2 billion? On another approach, which is the revenue approach, you're talking about a figure of 70 million. So even on the issues before your lordships, it doesn't follow from a conclusion that adequate indemnity requires you to disapply Section 78, that you're automatically giving my clients 1.2. I mean, if you did go down the route of saying Section 78 needs to be disapplied, I would certainly be contending, my primary case would certainly be
Yes,
1.2.
Well, thank you very much.
Does that answer my Lord Clerk's point? Okay.
An answer anyway.
It's a bit like a Court of Appeal, a Court of Justice judgment. One is never quite sure.
Thank you very much. Mr. Swift, anything you want to say about that?
Only to draw your attention back to when it was issued, what you said. Issue 1 is the meaning of Section 78. The second issue is then the compatibility of that meaning with EU law. If you get beyond that, if the answer on issue 2 is in favour of Littlewoods, one then cannot simply play with percentages. One needs then to identify what the English law cause of action is, and then ask yourself, well, what result does that cause of action produce? So it's a slightly more discrete series of inquiries.
The narrow question is that it's not all or nothing, as it were. That's the point. Either the first stage is if you win on the second issue, then it's simple interest, end of story.
It's statutory interest will be.
If you lose on the second issue, then we're not necessarily straight into compound interest.
No, because one then has the
other
issue,
questions. Exactly.
This application, measure of recovery, and so on. Yes.
Okay.
But the way the issue 2 has been argued, we've been given effectively the two options that have been presented
Sort of
to
binary.
us are on the one hand, EU law requires reimbursement of losses, including lost value of money, relying on paragraph 25 and paragraph 27. And on the other hand, that adequate indemnity is a much broader concept. And the way the argument has been presented is that for us to hold that Section 78 is incompatible with EU law, we would have to uphold the former argument.
Well, my lord, that's precisely so. You haven't been presented with the middle way by Littlewoods.
No.
My case has always been that the statutory provisions are good enough for EU law purposes. But you're right, the way that Littlewoods put their case is that it's reimbursement. Reimbursement means the time value of money. And so actually, you're right, you have this binary choice. There's been no submission to you to the effect that a middle way is available, or what that middle way might be.
Well, that was what we were asking about.
Yes, I think Lord Clark's question is really putting a third possibility on the table, which is that your submission is accepted that adequate indemnity is something to be broadly assessed, but that on these facts it might mean a more generous award than Section 78 allows for.
If that's where the court went, one question that would certainly arise would be in relation to the cause of action in English law that would actually be available to give effect to that an EU law right that had that shape. It certainly would be, I think, on my feet, it seems to me it might be more difficult in those circumstances to say that a restitution claim meets that shape simply because it's to do with the recovery of benefit. So if you went down that route, I think one would then need to look again at the way in which the consequent issues in this appeal, in particular issue 6, issue 3B and issue 6B, we would need to look again at the way in which they were formulated. You would note at the end of 6B, one point I make is that the restitution claim doesn't fit the right if the right is as Littlewoods say it is. And so you should then look for some sort of damages claim as the way in which English law would give effect to the EU law right. It may be on this analysis of there being a sort of middle way, the cause of action you would be looking to in English law would be by way of a damages claim, because only that could accommodate the middle way outcome.
Issue 6, what assumptions does issue 6B make as to what has happened earlier?
Issue 6B assumes that you have decided issue 2 against me, that you have decided issue 3B, selective disapplication, against me, that you've decided issue 6A, English law measure of restitution, in my favour. But the question then is, do you need or are you able to mould the English law recovery in restitution to meet the EU law right, or is there something else that English law can do that would realise that right other than a moulded restitution?
And if you could, I know this probably looks back at issue 1, but if you could, as a matter of English law, do that, would, so that there was an EU right of that kind, then what effect would that have on sections 78 and 80?
I think that the premise of your conclusion on the shape of the EU law right would be that it was not, that section 78 interest, statutory interest, would not be good enough to meet the requirements of that right, even though the EU law right was not equivalent to reimbursement. So you would still be in the situation where your first step would be to consider the disapplication or modification of section 78, section 80.
And there's quite a big difference between disapplication and modification.
Oh yes, quite so.
I hadn't thought that so far, at any rate, there's been any distinction drawn in the argument between disqualification and modification.
Well, that is what issue 3A and 3B is about. The 3A is Littlewood's contention that one doesn't need to disapply, one can modify. I say not. I say one's into disapplication, and then I raise a point as to the scope of disapplication. So the distinction between the parties on that matter is the next point in the list of issues.
I just say something very briefly
I
in
wouldn't
response to that rather long explanation.
Yep.
Issue 1 is the statute, obviously. Issue 2 effectively says that if you think that giving 24% is not adequate, then you have to disapply the statute.
Exactly.
Now, at that point, what you do is actually up to you. We say, because you could disapply the statute in a number of ways, we'll come to it. That's what issue, as my learned friend says, issue 3 is the next step. If you have to disapply the statute to give effect to European law rights, then one issue that you'll have to have in your mind is, well, what is the content of the European law right? How far does that take you? Now, it may be that you say that it takes you to adequate, and adequate is 70% or whatever. I'm just making that up. We know that section 78 cuts you off at less than 24%. It's perfectly, I guess, the argument will have to be, or one of the things that your lordships may wish to hear about, is when you disapply, which on this basis you would, section 78, so as to ensure that we weren't given an inadequate indemnity, does one do it in a way which gives effect to the European right? Plainly, that is affected by how your lordships see the European law right and what you think is meant by adequate indemnity. So it comes up in issue 3, where if your lordship say 30% would be adequate, but 24% isn't, therefore we're going to disapply until the point where you get 30%. Or as we submit, when you get to issue 3, and you're into the disapplication, there's no limiting principle. You disapply fully, but we may not be right about that. So that's the point in which one is forcing English law to yield to European law and to have the content of the European law right.
Thank you very much. I think the sensible course is for us to, I'm rather up and down, but I think the sensible course, in light of your answers, is for us to adjourn briefly further. And we'll be back, I hope, inside 5 minutes. Court's now adjourned. Maybe good for our circulation not to be sitting throughout the afternoon, but I'm sorry to have kept you waiting yet again. Thank you very much for your patience and for your answer to the questions. I should explain where we've got to, and we would like your submissions as to where we should proceed on the basis of where we've got to. We're conscious that you may want to take instructions and even discuss it. So if either of you feel you would like to come back tomorrow morning to discuss what we do, please don't hesitate to say so. But if we can agree where we've got to and what's going to happen this afternoon, so much the better. We are of the mind that we should, despite Mr. Rabinowicz's formidable arguments, that we should nonetheless dismiss the cross-appeal fine for the revenue on issue 1. On issue 2, we are minded either to allow the revenues appeal or to make a reference. And in those circumstances, the question is whether there is any point at this stage in dealing with the other issues. As we see it, and you'll correct us if we're wrong, if we were to allow the appeal on issue 2, then the other issues would fall away. If we were to refer on issue 2, then if the Court of Justice came back with a decision which was still part of our law to the effect that we should have dismissed issue 2, then that's the end of it. Allowed issue 2, then that's the end of it. If, on the other hand, we should have dismissed on issue 2, at that point it would be necessary to go on to consider the further issues. But it seems to us that on that hypothesis, which A, involves us deciding to refer, and B, the Court of Justice indicating that we should, as it were, dismiss the appeal on issue 2, it would only then be sensible to consider the outstanding matters. But you may, A, want to take instructions, B, want to discuss it, and if you'd like time this afternoon to see if you can consider it, that's fine. If you'd prefer to consider your position overnight, then it's entirely right that you should have that. I don't know if you want a brief word now, whether you're in a position to indicate fairly confidently what you want, but please, as I say, don't hesitate to say if you want us to come back tomorrow morning, you've got every right to ask for that.
My Lord, if possible, if we could use the time now to see where we get to, that would be very useful.
Lord, I would endorse that.
Okay. Well, we've kept you waiting a bit, so you've got the right to keep us waiting. Shall we come back? We will say we won't come back till 5 to 4. We've got
Grateful,
time.
my lord.
If you want a little bit more time, that's fine.
I think that should be fine.
Thank you very much. Court now adjourned again.
Yeah.
My Lord, both of us think that, given the indication you've given, it would be sensible to stop argument now. Obviously, if the appeal on issue 2 is allowed, the reason for that is obvious. If the court decides to refer issue 2, there is the risk, we understand, that when the reference comes back, it might be that either or both of us wishes to reformulate the way in which the consequential issues would be put, or indeed reformulate what the consequential issues are. And so in those circumstances, if we continue to argue, it may be simply a impractical exercise.
That's agreed.
My lord, yes.
If it helps, it is the way it seemed to us, but we thought that you should have an opportunity to deal with it. Well, we are very grateful to you both for the way you presented your arguments. It was very clear and very helpful. And we're also grateful for the written cases. We will consider our decision, and insofar as we haven't let you know it already, we will let you know it in due course with our reasons, no doubt, after, I suspect, the summer vacation.
My lords, before you rise, I'm told by one of my juniors that I need to mention Rule 46 of the Supreme Court rules and the question of costs.
Yes, you could mention it, and then we can leave it there. For some reason, our rules do, and you're absolutely right, say that question of cost should be raised. The fact that we never, or hardly ever, deal with costs until we've decided the case doesn't seem to have impinged on the rule makers. And since I think I'm ultimately responsible for the rules, that's a self-criticism. But thank you for mentioning it. Thank you for reminding us of the rules. And having mentioned it, you've done your duty. Thank you. Court is now adjourned.